There are countless social policies and specific pieces of legislation that affect many aspects of family life. From how families are created to how they function, these policies have both micro effects on individuals and macro effects on society as a whole. We will focus on 3 adoption policies with far-reaching effects: the Omnibus Act, the Adoption Assistance Act, and the Multi-Ethnic Act. We begin with the Omnibus Budget Reconciliation Act of 1993, also known as OBRA. Passed during the Clinton administration, this act was the first piece of legislation to guarantee adopted children the same access to insurance coverage as biological children, and supersede any and all state laws regarding the matter. For many years prior to the passing of OBRA, employers and insurers sought to decrease expenses by dropping coverage for adopted children. OBRA guarantees adopted children the same health coverage as biological children, upon placement and without restrictions based on pre-existing conditions. This means adoptive children cannot be denied the same benefits that biological children receive, even if there is a pre-existing medical condition before adoption. Receiving benefits upon placement with a family is crucial, as adoptive placement periods can range from 3 months to several years. During this time, adoptive families were entirely responsible for medical expenses of the child. OBRA positively impacts many groups, yet there are still some it fails to cover. OBRA does not cover adoptive children of federal, state, and local government employees or military workers. The passage of OBRA was a notable step toward equal access to resources for adoptive families. Previously, adoption, especially of a child with a pre-existing condition, often meant parents would be paying expensive medical bills without the assistance of any insurance provider. OBRA largely eliminates this concern by offering adopted children the same benefits as biological children. The international adoption rate in the United States doubled in the 1990s. OBRA was likely a partial contributor to this spike, as adoption became more financially manageable, alleviating pressure from financial concerns and creating a less strained adoptive family dynamic. Time could be shifted away from worrying over medical expenses and bills and toward positive family interaction.
This is the Adoption Assistance Act, which was introduced to Congress on April 4th of 1979 and was signed by Jimmy Carter on June 17th of 1980. The Act's basic function is to help the foster care system, and it pays close attention to the special needs children placed in the system. Why did the foster system need help? Many people were unsatisfied with how the foster system worked, and especially because the foster care drifts. The foster care drift is the increasing amount of time between when a child is placed in foster care and then either returned home or placed in an adoptive residence. This increase in time is a problem for both the system and the children. But what does this law do? How does it help? This law requires states to make adoptive assistance payments to adoptive parents of special needs children, and this will help cover the extra expenses of taking care of a special needs child. It defines special needs child as a child who can't return to their parents' home, hasn't been able to be placed without assistance, and has a special condition which will justify the assistance. For all children placed in foster care system, the state must make a reasonable effort before removing the child, and a reasonable effort to return the child to their parents' home as soon as possible, if possible. States must have reunification and prevention programs for all in foster care, and must place children in the least restrictive settings possible. States must review all cases of children in non-permanent homes or foster homes every 6 months, and then must decide where the child will be placed within the future within 18 months. This future will consist of either returning to their home or being placed in an adoptive parent's home.
The Multi-Ethnic Placement Act. The Multi-Ethnic Placement Act of 1994 was made in response to a belief that policies that gave consideration to race, color, or national origin in making foster care and adoptive placement decisions often created a barrier for children of color. In 1996, MIPA was amended through the Interethnic Adoption Provisions. The purposes of MIPA IEP are to reduce the length of time that children wait to be adopted, help find and keep foster and adoptive families, eliminate discrimination on the basis of the race, color, or national origin of either the prospective parent or the child, carefully choose foster and adoptive families that reflect diversity of children, help children, specifically in the child welfare system, find foster and adoptive homes faster and more easily, recruit foster and adoptive parents of all backgrounds. The law prohibits denying anyone the opportunity to become an adoptive or foster parent or for a child to be adopted or put into foster care on the basis of race, color, or national origin of the adoptive or foster parent or of the child involved. It was, however, not intended to prohibit same-race placements. The law is enforced mainly through funding. If a state's program is found to have violated the guidelines and not tried to correct things, the government will reduce payments to that state. In addition, any other entity in the state which violates the guidelines has to return all of the funds the state provided. Failure to comply with MEPA is a violation of the Civil Rights Act. The term transracial adoption means the joining of racially different parents and children together in adoptive families. Before the Multi-Ethnic Placement Act was passed into law, a 1987 study found that only 8% of all adoptions included parents and children of different races. It also found that 1% of white women adopt black children, 5% of white women adopt children of other races, 2% of women of other races adopt white children. After passing MEPA, an estimated 15% of the 36,000 adoptions of foster children were transracial or transcultural adoptions. In a study, transracial adoption was found not to be detrimental for the adoptee in terms of adjustment, self-esteem, academic achievement, or relationships. Congress expected MEPA and IEP amendments to decrease the length of time that many children of color wait to be adopted and prevent discrimination in the placement of children. However, testimony presented at the hearings on MEPA often focused on issues in African American adoption issues and discrimination without examining the specific circumstances of Indian children in foster care. While the IEP amendments provide new guidelines for foster care and adoptive placements, these new guidelines do not apply to placements made for eligible Indian children under the Indian Child Welfare Act. The ICWA is a federal law that seeks to keep American Indian children with American Indian families. Congress passed ICWA in 1978 in response to the high number of Indian children being removed from their homes. The intent of Congress under ICWA was to protect the best interests of Indian children and to promote the stability and security of Indian tribes and families. The ICWA requires that courts apply different rules in cases if they involve a Native American child. Other federal laws, state laws, and constitutional principles prohibit taking into account the race or ethnicity of other children. In conclusion, adoption is a great thing for children who need homes. In our presentation, we explored how through the Omnibus Act, adopted children are granted the same access to insurance coverage as biological children. We saw how the Multi-Ethnic Placement Act prevents discrimination when placing children into adoptive and foster homes. And we learned how through the Adoption Assistance Act, there is a goal to help keep families together and children out of foster care or other out-of-home placement options.